The topic to be presented today is the issue of capital life without parole. I contend that capital life without parole violates the Eighth Amendment to the Constitution that prohibits cruel and unusual punishment. And I contend that is the case because a judge or jury is precluded from hearing evidence of mitigation in determining the proper sentence for an individual who has been convicted of murder and is given an automatic sentence when capital life is sought of life without parole. There is no vehicle whereby a judge or jury is able to incorporate evidence of mitigation in making a determination as to the appropriate sentence to give to an individual. Indeed, we have a trend in the Supreme Court in recent years that emphasizes the need to address the evolving decency that marks a maturing society in the criminal justice system. I want to talk a little bit about two cases, Eddings versus Oklahoma and Alabama versus Miller. And I will quote directly from Eddings. The Eddings court indicated that a jury or judge should not be precluded from considering as a mitigating factor any aspect of a defendant's character and any circumstances of the offense that the defendant proffers as a basis for a sentence less than death. Now, obviously, in Eddings, a death occurred and the death penalty was sought. But it is equally applies to capital life in that obviously in a death penalty case the court emphasizes the necessity to present evidence of mitigation if such exists so that the jury can make a determination as to whether or not the individual receives a penalty of death. And certainly if the death penalty were to be automatic, it would absolutely be unconstitutional. So the same should apply to cases involving life without parole. In Miller versus Alabama, the Supreme Court talks about the evolving decency that marks a maturing society. And we have, for instance, situations involving circumstances where a mother who takes the life of a child under the age of 10 is subjected to a capital case. And if in fact the state decides not to seek the death penalty, which it could, but decides to go for capital life, the mother who must or might be suffering from a postpartum illness, to include postpartum psychosis, is prohibited from demonstrating that issue to a jury with an automatic sentence of life. And we believe that violates the Eighth Amendment to the Constitution of the United States, again, that prohibits cruel and unusual punishment. In 2009, the Texas legislature, following the path of the evolving standards of decency that mark a maturing society, heard evidence on a bill, House Bill 3318, that dealt with reducing the offense level of a that attaches to a mother who is suffering from postpartum psychosis, and harms or takes the life of a child within 12 months of the birth of that child, reduces that particular offense down from capital murder to a state jail felony, totally in recognition of the circumstances surrounding the taking of that child's life, with provisions of mental health care. That bill was voted out 7-1 onto the calendar committee for presentation to the legislature, but unfortunately the time ran out and that bill never made it out of the calendar committee. It's simply an example of how even Texas acknowledges that we have a special set of circumstances surrounding this particular type of infanticide, that is the taking of a life of a child by a mother suffering from mental illness as a result of that childbirth. In the 20th century, over 29 countries have on their books statutes that address the mental illness of a mother who takes the life of a child within 12 months of the birth of that child if that mother is suffering from mental illness as a result of childbirth, specifically postpartum psychosis. I also believe that by denying recognition to mothers who suffer from this illness and in fact harm or take the life of a child, in effect denies a definable group of individual citizens in this country, denies them equal protection of the law in violation of the 14th Amendment to the Constitution of the United States. I think it's high time that we as a community not only address these issues from a legal perspective, but understand the reality of what we're dealing with when we deal with a mother who suffers such horrible circumstances as a result of the natural act of giving birth to a child.